we are going to have a look on the proposal for a directive on the European Parliament and the Council on mutual admissibility of evidence and e-evidence in criminal proceedings. We have an extremely wonderful panel here, both present and online, and so I think we will have a very good discussion, hopefully. Lorena will start in a few minutes setting the scene and make a presentation of the project's work, and then we will continue from there. And unfortunately, there's not much time left for each speaker, 8 to 9 minutes, and so you have to bear with them. I know Pedro has a presentation. It will not be given out now, but it will be available on the cloud from this meeting. So you will have to look at it, be able to look at it afterwards. It has some very interesting details. But I want to welcome you all very much this afternoon to the first presentation. And I know after lunch, it's like when you're teaching students, nobody wants to come and they want to continue with their lunch. But Lorena, will you set the scene and take us into this draft?
Thank you very much, Anne-Brigitte. So first of all, good afternoon to everyone. I mean, first thanks is to all of you who are here, despite the siesta time here in Spain. So thank you for having this very selected audience. Thank you, of course, to the organizers for this wonderful annual meeting, which is, as everyone has commented, it runs so smoothly. Then we see how much work there is behind. So really flawless, really exceptional. And obviously, I have to thank my co-reporter, who is Professor Farsam Salimi of criminal law at the Wien University, who couldn't come to this meeting, but obviously we have worked hand in hand together with the invaluable team and the group of advisors that we are very privileged because they are all they have provided an invaluable contribution and an excellent feedback to improve this legislative proposal. So I feel really very privileged, and this is my last thank you to be sitting in this panel with Professor Silvia Allegrezza, who is one of the best experts all around Europe in criminal law and working in Luxembourg University, but speaking all kinds of languages and a renowned speaker all over. And obviously our chair, which I do not need to present because you all know her. And on my left side is a very renowned public prosecutor, which is Pedro Pérez Enciso, who is really one of the most salient experts in any kind of issue related to judicial cooperation and fighting transnational crime. So thank you, all of you, for allowing me to share this panel with you. And now coming to the content. For those of you who are not specialists in criminal law, and I know this topic might not be admissibility of criminal evidence and electronic evidence in criminal proceedings, or might not be so catchy as climate justice and climate change, which it kind of addresses the interests and the urgent needs for everyone in this world, in this global world. Our aim and the project wanted to develop certain admissibility standards on criminal evidence when it comes to cross-border proceedings. So what is the problem there? Again, for those who are not very much familiar with this topic, which is a very much focused one, but at the end has a great impact in everything we have heard this morning, which is fighting transnational crime and any kind of organized crime. So it affects the security of all of us and, of course, our fundamental rights. So we are facing, for the last decades, I would say for 30, 40 years, an increasing cross-border criminality, or a criminality with cross-border elements, be it because the assets, the profit-led criminality, are located abroad, or because of the electronic evidence, which is located somewhere abroad or somewhere in a server, we don't know, which is the cloud. So this poses huge challenges for effective criminal prosecution, but at the same time, also in fighting transnational criminality, poses great challenges to the defense rights, who have to really present their defense not only against the evidence presented at the forum, but also evidence gathered in another country under different rules, and what kind of rules, if they are complied or not complied, and so forth. No, and this challenge has increased and will be even higher and higher since the European Public Prosecutor's Office is gaining more and more importance, and since the fraud against the financial interests of the European Union will be also one of the focus to be very much paid attention to in our role of taxpayers within the European Union, because of all the huge subsidies and huge rescue funds that have been allocated by the central bank to our national countries. So problem is in cross-border criminal prosecution and cross-border criminal defense. And this is an effort to provide some kind of rules, standard rules, or approach of rules, harmonized rules on admissibility of evidence since the Tampere Council in 1992. So why it hasn't been moving forward in these 30, 40 years? In creating an area of freedom, security, and justice, it has to be based on the principle of mutual recognition. This is set up in the Treaty of Functioning of the European Union, and many, many directives and framework decisions have already been issued and adopted in this sense. The question is realized that precisely one of the competences that has been allocated to the European Union legislator, and it's the only one that has not been developed in creating the area of freedom, security, and justice, is precisely the rules on admissibility of evidence. What happens with the evidence obtained in another country and it's transferred to the forum state and be used as criminal evidence. So should it be directly admitted? Because this would be complying with the principle of mutual recognition. But if we apply strictly the principle of mutual recognition, which is one of the aims of this area of freedom, security, and justice, at the other side, we encounter the risk of what we call evidence laundering, that the evidence obtained in another system under different rules is simply assessed without any other checks in the forum state, which is called the principle of non-inquiry, or what we call evidence laundering. So this draft proposal, it's only a proposal which we have been discussing with the members of the European Union Commission, and we have also called up the European Judicial Network, OSCE, which you saw one speaker this morning, and checking in which way a legislative piece should enhance the prosecution, effectiveness in the prosecution, and by, at the same time, not creating an obstacle to mutual recognition, but enhancing also the defense right. It contains also some rules on electronic evidence, some standards that should be complied in the storing, in the transfer, in order to ensure integrity and authenticity, which, according to cyber people, it's impossible to ensure to 100%. You won't find in this legislative proposal any definition of what is electronic evidence, only for the aims on application of this draft proposal, and it's not a code of electronic evidence or new tools on electronic evidence, only the principles upon which evidence obtained in another member state should be admitted and not admitted, in order to enhance the circulation of the free evidence circulation, but not minimizing the defense rights. So I stop here. we have a big problem in trying to strike the right balance, because this is not easy, and we have tried to stay on a realistic path. On a realistic path because, as I told you, there have been already 30 years proposals and real efforts by the Commission to move forward with such a piece of legislation, and member states in the Council just opposed radically to anything that would change their own national rules on admissibility of evidence. And this is why we opted for very limited exclusionary rules of evidence, which are undiscussed, undebated, and already recognized by the European Court of Human Rights and also by the Court of Justice. And on the other side, promoting admissibility so that we can really, within the area of freedom, security, and justice, promote that criminals that move freely through all our geographical countries and our geographical space are not benefited by our fragmented legal systems. I'm sorry if I took more time, but thank you anyway for your generosity, Mrs. Chair. Thanks.
Thank you so much, Lorena. No, it was very good. And you set the scene and the presentation of the work perfectly. And I really admire you, a fast speaker. So that was very good. Pedro, you have already been introduced, and so Lorena did that. That's very, very good. And now you will give us, I think, some thoughts on the need for supranational rules on this, and also maybe some feedback on the draft, which you have already seen.
Okay. Good afternoon, everyone. Thank you for having me here. I'm really pleased and honored to be here representing the European Judicial Network. For those of you that are not actually familiar with what the European Judicial Network is, the European Judicial Network is a network of experts in the field of judicial cooperation that belong either to the judiciary, to the prosecution services, and also officials of the ministries of justice, distributed among all the member states and within the secretariat of the EGN. I will use the acronym from this moment on. In my presentation, I was asked, since I am one of the contact points of the European Judicial Network, to participate in this event. And again, I'm really pleased to be here representing the European Judicial Network. What I have done is to read and reread and go over all the provisions of the draft directive. And I have made a number of comments, which I have already shared with Lorena and also with the other representatives of the board. And since there are like very many details on every single article of the draft proposal, I really don't know how to address this presentation, because I guess going over all those detailed comments would take me 1 hour or so. And I really don't want to bore you with this. And now I learn also that you are not experts in the field of criminal law. Some of you are, others are not. So I really apologize for that. So just some general remarks. My idea is to present very briefly, in a nutshell, my general remarks on the proposal, also the inputs that I have received from the Secretariat of the EGN, and still work on the document. If that is acceptable for Lorena and the rest, the idea is to distribute this document among those members of the European Judicial Network that belong to a concrete group, which is the e-evidence working group. There is like, around 10 people working on this e-evidence group. in this group, we have been actually working on the Commission package on electronic evidence, which is not the topic that I'm going to address at this moment, because that is a very different topic. That is a package of regulation and directive which is addressed to how national authorities dealing with a concrete investigation are going to interact with online service providers, which has nothing to do with this proposal, so I'm going to leave that aside. This is just for the record, because that was in the initial information that was provided for my intervention, and I will just catch upon what Lorena said. This is the issue on jurisdiction. I mean, jurisdiction has when it comes to electronic evidence, has absolutely nothing to do with the field, with the country, with the territory. So we have to change our mindset and think about jurisdiction. Who is going to take over jurisdiction about this concrete case, taking into account other different issues apart from the territory. Because maybe the territory that has been affected is Estonia. We all remember that case in Estonia, and maybe the attack has taken place from another country, Russia or other country, whichever it is. Who is going to take over the case? Maybe a cyber attack takes place simultaneously from different jurisdictions at the same time, and it's another country that is actually affected. Who is taking over the case? We have a lot of conflicts of jurisdictions in these situations, and how are we actually solving this situation? We are normally, I would say that Spain has not a very wide experience in setting up joint investigation teams devoted to electronic evidence, but we have quite some cases, and we have always addressed this conflict of jurisdiction in the context of joint investigation teams, and in this context we have shared the information. So which are the evidence which is the evidence that you have, which is the evidence that you have. If I transfer my case to your jurisdiction, are you going to be able to use this evidence? For instance, I recall one case, a case that I had in the context of this directive. Recordings of wiretappings is electronic evidence. We had this case where Portugal couldn't take over an investigation that we had because they needed judicial control every 15 days. And they said, oh, okay, in Spain the case is completely different. The judicial control can be every month, every 2 months, every 3 months. So we cannot use that evidence, because it wouldn't be against the constitutional principles, because that is like the limit. If the evidence is against the constitutional principles, we can, in principle, not going to be able to use that evidence. But this is just a procedural rule. This is not affecting the constitutional principles of judicial supervision. So maybe if this proposal comes through, we can find a way to circumvent that difficulty. So that's like a general remark. I think that of course also we should also bear in mind that it is thought that the Commission is going to launch the initiative for an instrument for transfer of proceedings, which is like the second part of the. We had initially a framework decision on conflict of jurisdictions in 2009. I think was passed that instrument that has never worked at all. I don't know one single case. I tried to instigate an authority from my country to come on, use this. You know that there is an investigation going in France. Use this framework decision on conflict jurisdiction. Ask for the information, but it never happened. I have never told about one single case of this instrument having been used. We have transposed it in our national legislation, but never used it. And the second part is, once you know that we have conflicting cases. We have the non bis in idem being at risk. Then we have to decide which is the best place jurisdiction and how to transfer, because part of the assessment, the criteria that need to be assessed is, can we use this evidence? Where has the evidence been gathered? Can we use it? In which way can we use this evidence? And this is part of the package that's going to be launched by the Commission. I heard only yesterday or 2 days ago that this is going to be launched in the third semester of this year, so maybe tomorrow, I don't know. So, and I think that to a certain extent, this proposal might overlap with that idea. I don't know. We have to read further on that possibility. But I think that, generally speaking, there's a general rule that the more harmonized the criminal typologies and the procedures for gathering evidence are, the more chances we have that actually that evidence that is transferred among member states is admissible and can be used in other countries. So I think that is the idea behind of the document, and I really think it is really important. There are, of course, some provisions in this directive that are not particularly they're relevant for every type of crime, but are not particularly relevant for this evidence we're dealing with, like those provisions foreseen in Article 5, absolute inadmissibility of evidence, provision of self-incrimination, provision of the circumvention of the right to refuse to testify, or some the breach of the right of confidentiality between the lawyer and the defendant. So those are important, of course they are, but they are like not only for this type of crime, but for all type of this type of evidence, but for all type of evidence. So this is the way where I think that the proposal might overlap in a way. We will see what is the content of this proposal and see how this proposal goes forward. I think that there are, like, for me, the most important from the side of the practitioners, which is my side, of course. We will see the side of the academics after me, I think. This possibility foreseen in Article 4, 1, 2, and 3 are like of paramount importance. And to be honest, we have precedents on this. We have the Council of Europe Convention on Transfer of Criminal Proceedings only 50 years ago had a very similar provision saying every single piece of evidence gathered in France can be used in Italy once this instrument has been ratified by both member states, where there are some exceptions, some, of course, guarantees, etc. But the principle was there only 50 years ago, because the convention is there of 71 or 72. I don't recall at this moment. So it's good that we come back to this principle. Of course, the things have changed a lot. The world has become a much more complicated scenario, and there's a lot of situations that we need to bear in mind that were not even thinkable back 50 years ago. But the idea is there, and there are some, of course, exceptions and deviations from this principle. I have this idea of fundamental constitutional principles and the idea of violation of the less lossy in the second part. Having seen how authorities across Europe work, if 1 minute. So I'm really sorry, because I really couldn't say just a few words. But this is going to be very risky, because we will have very different understanding on what is actually a violation of the less lossy, which for me is like the violation of procedural laws against the concept of fundamental constitutional principles. So that is going to bring about a number of issues and a number of problems. I don't know if this is only Article 4 and there are like 15 articles. I'm sorry, I couldn't. I don't know if this
No, this
will be
is so
distributed, but
it's very good, Pedro, and it's thank you for the very good comments already, and you will distribute it for the working group now, and they will take it into consideration definitely. And I like the view you said that with the from your side as a prosecutor. And now we will hear the academic side. And as we talked just before we started, I come from the lawyer's side, and I also see that I could have some comments also, especially on the independence and things like that. But I think we'll go on to our next, and we'll definitely come back to it, I'm sure. We'll go on to our next speaker, which is Tanja Schröder, and Tanja is now online with us. Tanja was not presented before. She is deputy head of the unit dealing with judicial cooperation in criminal matters in the European Commission's Directorate General for Justice and Consumers. And she has also been participating in the 2 legislative proposals, which you mentioned, Pedro, on e-evidence. And so, Tanja, the word is yours. And I know you also have some slides you would like to show us.
Thank you very much, and thank you for the invitation to speak at this panel today. I'm very honored as well. Can you hear me good? Well, is that's okay?
Yes.
Okay, thank you. So I'll try to share my screen now. Okay, let me shout if you don't hear. And so I'll try to stick to the timing as well as possible. First, little disclaimer. Of course, I cannot give, for example, feedback on the proposal on behalf of the Commission. It reflects a lot my personal comments. So just bear with me on that. Also to mention that we did in the Commission a study on cross-border use of evidence in criminal proceedings. The final report of that study, which was performed by Milieu Consulting, was delivered to us in March 22. It is not decided if the Commission will launch an initiative on this, but let's say that this is one of the ideas in the pipeline, which has been around for some time and which is literally gaining importance or justification with everything that's happening with the EPPO starting its work, etc. So let me start by a small context or problem setting. So first of all, judicial cooperation is to an extent involving the use of evidence or the transmission of evidence gathered in another member state. And this in an increasing way. We have this in different settings. We have this EIO or MLA setting where the purpose is precisely to transmit evidence or to gather evidence in another jurisdiction. We have the joint investigation teams where this happens also on a daily basis. We have the European Public Prosecutor, and as was mentioned by Pedro, of course, the upcoming proposal on transfer of proceedings, where one of the important questions is also how we can transfer the evidence that was gathered in the transferring member state. The topic covers all types of evidence, and I will address it generally, and I will also then go a bit into the specificities and the specific provisions of the evidence in the ELI proposal. On problems, if you have evidence gathered in another member state, which was gathered under a different legal regime, it can lead to difficulties in the forum where it's going to be used, where the rules will most likely be very different. And if this leads to inadmissibility, the whole purpose of the cooperation is, of course, affected. And you might need to start again the evidence gathering procedure, or you might not be able to do it at all. So it can lead to problems. The main issue here is that we have very differing rules in member states. That's also one of the conclusions of the study of the forensic procedures governing the gathering of the evidence. And one other problem found by the study is also that the communication between authorities is not always very good. In particular, for example, on the specific, if there are specific requirements in the state that issues a European investigation order on how this evidence should be gathered, this is not always made fully clear to the executing member state, which can lead them to problems later on during the trials. There's, of course, also a lot of different rules on the conditions for certain measures, investigative measures being, of course, can be very invasive, and so the conditions for who can order a measure, for which offenses is the measure available, can differ, and that can again lead to problems. On admissibility, we also have very different frameworks in member states. We have jurisdictions like Sweden, where there's a wider margin of appreciation of the judge. We have member states where there are stricter exclusionary rules. So that all leads to problems. It then has also another dimension, which is the defense rights dimension. The cross-border use of evidence can also affect the rights of suspects or accused person. And that beyond the interference with fundamental rights of the measure as such, there are different rules on the role and participation of the defense, and the fairness of the proceedings, on what is a fair proceeding, on what are the legal remedies available. And defense lawyers are very often also not aware of the rules, or of they don't get the information of how the evidence was gathered in the other member state. Now, so the objective of EU rules can be summarized as following. It would be to ensure the mutual admissibility of evidence and thereby contribute to an efficient area of freedom, security, and justice. And on the other hand, also ensuring minimum standards of defense rights and thereby contribute to a fair area of freedom, security, and justice. And that also leads to an interesting question of what should be the right legal base for the proposal, whether that should rather be a judicial cooperation legal base of Article 82, paragraph 1, or rather a legal base of minimum harmonization, minimum rights of individuals in criminal procedure, so the legal base used for the procedural rights directives, Article 82. And I see that the proposal of ELI has combined the two, which is also an interesting approach. In terms of legislating on this topic, there are different choices to be made.
Sorry,
the first one being...
Tanya, can I...
Yeah?
we have a little problem with the connection. You are not on the screen at the moment. And we also had a problem with the slides.
Okay, you want me to stop and to wait, or to continue?
No, I think you should continue. Yeah, but just to let you know that...
Yeah, okay.
I think maybe it's something which with the connection, maybe your connection on...
Okay, I don't get any messages, I don't know, but you can hear me all right?
Yeah, we can hear you, definitely, and we have a small picture of you, I can see in... Yeah.
Okay. Okay.
It's okay, thank you.
So in terms of choices for a legislator to legislate in this topic, there are different possibilities. You can propose general rules. You can then have specific rules for specific investigative measures or for specific types of evidence, such as e-evidence, or you can also have rules applicable only to specific offenses. And then a very important question is also, do you harmonize also the national cases, the national rules, or do you only legislate for the cross-border context? Just brackets regarding specific investigative measure. The Commission made a proposal for a new police cooperation code end of last year, and there they looked at the possibility of legislating, harmonizing conditions for specific investigative measure to allow a better cross-border cooperation, but that was then in the end not withheld as in the Commission proposal, because it seemed very, very difficult looking at all the differences between member states. And then what you can look at in terms of rights of the defense, you could regulate the role of the defense, the access to evidence and to information, how it was gathered, access to lawyer, as 2 member states will be affected, and the question of legal remedies. So in the ELI draft proposal, certain of these choices were made as follows. There are some provisions which are of general application, which can be found in Article 4 and Article
Tanya,
5.
you have 2 more minutes. 2 more minutes.
2 more minutes.
Two more minutes.
I'm almost done.
Good.
And in the key principle, I think, is in Article 4, which is the general principle of admissibility if the evidence is collected in compliance with the lex loci. And then there are a lot of, so this is the principle based on mutual recognition, and then there's a series of examples. There are then rules on inadmissibility of evidence in Article 5 based on elements of the Charter of the ECHR. I find it interesting that in particular the defense, the legal privilege is addressed, and also the communication with clergymen, but not the medical secret, for example. To finish maybe on electronic evidence, so there are 3 provisions in the proposal dedicated to electronic evidence. The starting point is that electronic evidence has special features, such as a higher risk of tampering with the evidence. You can also, with the help of artificial intelligence, do a lot of fake things there. So there's a lot of technical possibilities. And so you need special requirements to ensure that the evidentiary value of the evidence. And so there are provisions to ensure that. And the electronic evidence can also be very ominous, very voluminous, so that you might need special engines and tools to search it. And there are also some provisions to ensure that. There are provisions on rights of the defense in that context, and some room left for member states, which is also very interesting. We have not regulated anything on admissibility of evidence in the e-evidence proposal. However, the Parliament was very keen to have some provision, as this is still in the discussions. We will see if something comes out of there. I would also like to mention Article 8, and then I finish.
Tanya, I think we will have to stop now. I'm sorry.
Okay.
Because
no problem.
and there will be, please stay on, because there will probably be a number of questions, and you might be able to elaborate a little bit more afterwards. And as I said, we didn't see your slides, unfortunately, so I hope you will share them with us so that everybody can have access to them afterwards. And then I would like to give the floor now to Salvia, and who is also a professor, and we had an introduction, Salvia, a short while ago. So please, the floor is yours.
Thank you, Anne Birgit. Thank you so much to the European Law Institute for this invitation, and in particular, thank you to Lorena, who is a dear colleague, but in particular a dear friend of mine, and our favorite sport is to discuss for hours about criminal evidence, but feel on the safe side, I'm not going to entertain you for such a long time. So this very, very appreciated invitation comes with a very hard task, because I was required to present and to connect two topics that are strictly related. One hand, the rules concerning the European Public Prosecutor Office, and in particular the powers concerning cross-border investigations, and on the other hand, how the current proposal elaborated by Lorena and her colleagues could support the development of this very, very sensitive part of the work of the European Public Prosecutor Office. I was going around yesterday evening and this morning asking how much you know about the European Public Prosecutor Office, and I realized from the sample I had that, well, not that much. So I cannot skip, I think, a very short introduction on the European Public Prosecutor Office, the so-called EPPO. So the EPPO was introduced very recently. It's currently operative, it is in Luxembourg, and it's operative since June 21st. So just for you to understand, the EPPO is considered together with the SSM and the SRM, so the European Banking Union in general, as the main milestone in the process of the European integration of the last 2 decades. Why? Because for the first time within the European Union, not the entire European Union, only participating member states, currently 22 out of 28, are accepted somehow to have a common prosecutor in charge of investigating, prosecuting, and bringing to judgment the so-called EU frauds or crimes affecting the European budget. The idea in itself is very simple, but it's absolutely extraordinary and completely unprecedented, because for the first time in the entire history of criminal justice, we have a sort of separation between prosecutorial powers and adjudication. So we have a common prosecutor for these 22 countries for specific criminal offenses, bringing the case before national courts. So we broke the link between actio and jurisdiction, and this is completely unprecedented. So basically the idea, it's a purely academic product, and this is also something we are very proud of, was born at the end of last century, and basically it came with also the idea that a single legal office should go together with a single legal area. No, that makes sense. One prosecutor following the same rules within a certain larger area composed by many member states. But as Tanya should know better than me, the already shy proposal of the Commission was almost killed by many years of negotiations. So finally we have an EPPO that is a single legal office, and this represented absolutely an added value. We both wrote a lot about that, but it comes without a single legal area. What does it mean? It means that you have a handling European delegated prosecutor, that is the prosecutor in charge of the investigation, and the handling EDP determines both the applicable rules, so which national law is applicable, and second, which national court will be in charge later on for the trial. But the problem comes in particular in cross-border cases, so where you need to collect evidence in another country, in another participating member state. So in this case, you have the interaction of 2 or more delegated prosecutors. So we might have one handling prosecutor in the concrete case we are going to deal with, because it raised the question, the first preliminary ruling request before the Court of Justice. We have, for example, the German European delegated prosecutor in need of collecting evidence in Austria, because it's a large carousel fraud concerning VAT, and there is the need to collect documents, emails, every sort of evidence, for which the German prosecutor asks to the so-called assisting EDP, in this case the Austrian prosecutor, to go search and seize everything that is needed for this investigation. Unfortunately, the current regulation approved and establishing the European Public Prosecutor Office does not contain an efficient system, a complete system of rules concerning investigative measures and evidence. So finally, we have a very minimum list of 6 measures that member states are obliged to foresee in their national systems, and the large majority of them are coercive measures. So traditionally in criminal procedure, when you have to execute a coercive measure, a judicial authorization is required. But how do we handle this complex mechanism in which a judicial authorization is required in either the handling member state or in the assisting member state or in both of them? So how do we deal with a concept that is not defined by the regulation, that is left to national law, in cases in which the prosecutors absolutely need this judicial authorization to execute the measure that they need in order to collect evidence? Well, no solution is foreseen by the regulation, as I said, but inefficiencies are creating problems to the European Public Prosecutor Office. So what they did in Luxembourg, the College of the European Public Prosecutor Office came up with guidelines in January 22nd. But you understand that this has to go via a democratic debate, and it cannot be the prosecutorial part, despite the high quality of the work they've done, to decide autonomously what are the rules to be applicable to criminal investigations. This case concerning Germany and Austria raised the question because the Austrian judicial authorities asked the court in April this year, what is the concept of judicial authorization? What am I supposed to control? They tell me that I cannot control the proportionality of the measure. I cannot control the necessity. So what do you mean when you talk about the judicial authorization required in my country in order to collect evidence in my country? So let's wait for the court to give us an answer to that. So coming to the second point of my presentation, can the current proposal elaborated by Lorena and friends to support, can it support the EPPO? Can it make it better? Yes, of course it can. Everything that is related to harmonization of evidence can support the work of the European Public Prosecutor Office, not only of him, but of the entire machinery of justice, including the fairness of the entire procedure. So I don't have much time, and I will use the carrot and the stick strategy. So
1 minute.
Talking about, okay, in that case, I think I will leave the carrot and the carrot for the debate, and I will go straight forward to the stick, because this is the duty of the external academic of the panel. So what is the problem? I know how hard it is to have a debate on admissibility, and in particular on non-admissibility of criminal evidence. I know. But I noticed that in the proposal there are many unclear concepts that have been used. For example, excessive interference, unacceptable coercion, arbitrary interference. This concept I know because I know Lorena's background. They come straight forward from the European Court of Human Rights case law. But what is the problem? That the European Court of Human Rights intervenes once that the final decision has been adopted. So the famous criterion of the procedure and the fairness of the procedure as a whole, it works once that you have in front of you the final decision, and you can assess counterbalancing measures, and you can go for the fairness of the proceedings as a whole. But from there, we need to distillate concrete rules. We need specific rules to be applicable ex ante, because this is not an ex post judgment. This is an ex ante assessment. Second remark, I think we have to abandon this logic of compromise and this total ban of the governments. They don't want to discuss criminal evidence. I mean, this is a brave new word, as Pedro said. We need brave new rules. And in particular, we need to avoid the erosion of the very concept of evidence. Because what I noticed in the debate of the last 5 years is a way to destroy the very concept of evidence, that in its traditional vision is related to human beings and to human behaviors. We talk, we move in space, we meet people, we have a certain physiognomic appearance, whereas now we only talk about evidentiary results as data, and on the other hand, as electronic evidence, which is the support. But the content has to be related to human beings and to human behaviors, not to the way the data are contained, transferred, or processed. And that's it for the time being. Thank you so much.
Thank you so much, Sandra. This really shows how important this topic is. Now we have a short period of Q&As, and are there anyone who has questions? Anything you would like to touch upon? If not, Lorena,
Yeah,
you probably have.
I'm sorry, I always have. I'm the obnoxious questioning person always. Yes, I have a lot of questions and a lot of clarifications. I'm not sure how far you have been able to follow. I'm sure, despite the time, you at least have been able to grasp the depth and the scope of the problems. If I put you a simple example, you will follow it much more. So, for example, someone is using your image in Germany because you posted something in Instagram, and then you try to sue them, and or they open a criminal prosecution. So where is that evidence? Where is this photograph? And it's really distributed via Instagram all over. Where is the jurisdiction? If you want to really, this image of yours has been used for example, a porn film. Okay, so no one wants to be put face or body in a porn film. No, this is a type of transnational crime, and you want to prosecute that. First, not only closing that image and that publication online, but also finding who is the perpetrator and sanctioning it, because this is the aim of the prosecution. There would be a very simple example, how to find out who posted it. You need information for the internet service provider, then it has to be sent over. Once it is sent over, is it real? Was it the person, the IP that we get matches with the person who put it there? What kind of evidence? Can we call him in? Are there witnesses? How to interrogate the witness? And then when you find everything that's happened outside of your country and is to be introduced in the forum state where the trial takes place, then you find out, no, it's not admissible because it was gathered following other rules, because in our country you cannot, in that country abroad, you cannot intercept or computer communication or access to a computer unless it is a very grave crime, or in the other way around, no? Or there is no judicial authority or whatever. So that's one problem that could affect us all. The other problem is much more deeper, which is economic crime and fraud against the financial interests, where the fraud on VAT carousel always involves several countries, no? And there might be also information from tax agencies and from OLAF, so the Office for the Fight of Fraud. And those are administrative offices. And if they provide information, reports, they gather their own evidence under the administrative rules, and they send them over, for example, to Spain for Pedro to prosecute it, or if Pedro works, the delegated European public prosecutor to open a criminal investigation here, can they use that evidence, which is produced by an administrative body and under absolutely completely different rules? And some countries really absolutely reject it straight away, and some other countries just say, bring in everything we can have against the defendant. And this is creating a completely nightmare for defense lawyers as well as for prosecutors. And this is why we are trying, so to say, a little bit to regulate. In addition to that, we have tried also to introduce certain standards on electronic evidence. So this is a kind of a mixed instrument on principles, comply the rules, as Pedro has mentioned, that already existed in mutual legal assistance back in the 70s. Whatever in the executing state is done according to their rules, because we are not able to check them, we will admit it as if they were produced according to our own rules, and we won't discuss it. So respect the principle of lex loci. But in order to enhance this, the defense rights, which is an area of freedom, security, and justice, also for the defendants, let's check if this has been obtained complying the fundamental rights, not only of the forum state, but also ensuring that the defense lawyer can have some possibility to check how that evidence was gathered in a foreign state. So I'm very much aware that this proposal will not please everyone. It might be some of the mediators say that when the two parties go away absolutely upset, it means the mediation worked well because no one won. And of course, we used very unclear concepts for exclusionary rules, but there was no other choice to say strict in which conditions or under which conditions member states should really apply exclusionary rules. On the other side, I fully agree with you that the assessment of the European Court of Human Rights is an ex post assessment. However, when we are talking about admissibility rules in most member states, admissibility is not an ex ante checking like in the common law countries, but it's already within the trial, and it's the adjudicating body who decides. Already ex post, so after the evidence has been introduced into the trial, and of course it's different than after the judgment, but at least there might be an assessment by the court after the gathering and assessing how it has been gathered, and the court can probably interpret these very unclear concepts of general concepts. To your question on the violation of lex loci and fundamental rights, of course, what the defense lawyers wanted is to say, if there has been any kind of violation of lex loci, be it in a substantive way or in a procedural way or in a proportionality area, the evidence should be completely excluded. And our argument was, but this would destroy the mutual recognition principle, so this directive would not ensure certain admissibility. It would kind of increase the fragmented area unless we really regulate an harmonized code of procedure and common rules on investigative measures. So we tried to say at least the procedural lex loci rules should be able to be checked by defense lawyers. How? Ensuring that defense lawyers in the foreign state have access at least to a legal expert who is aware of what is the law to be applied in the executing or production state and how the evidence was obtained there, and at least if it was according to the legal standards or not. Fundamental rights, checking the fundamental rights in the forum state, obviously it's not easy. But this was kind of introduced following the text of the European Investigation Order to say at least the receiving state, when assessing the evidence, should check something. And this something is at least that it complies with what is considered the common culture of fundamental rights. Sorry, I talked too much. Always.
No. It's yeah. That was what I was going to ask you to do.
And I will start from the end. And actually, you touched upon one of the questions that is actually a nightmare for us with regard to the European Investigation Order, the proportionality. So, in principle, that lies or should lie with the issuing state. I think that is a principle. That's a good principle. It is in Article 6 of the directive. That's okay. But when we have to execute that, in my case, like this every single day, so you come across situations where they ask you to conduct a financial investigation because someone has stolen a package of cigarettes. Is that proportional or not? So what we do there is we ask for additional information. Maybe this guy is involved in a scheme of either organized crime, is stealing thousands of packages of cigarettes. And still, that is not a reason for refusal according to Article 11. So in the end, you try to conduct, but you cannot. And you are using like a lorry, a big lorry, to investigate a very little thing. So I now call for the responsibility of issuing states here. So, but there is very little we can do there.
Sharing costs.
That is something else. We have the instrument of preservation. So preservation means that whenever you are conducting an investigation, and you need information from online service providers, before you ask for subscriber data, traffic data, content data, everything that you are really going to use in the context of an investigation, normally at police level, you can just ask, I don't know, Google or Microsoft or any online service provider to please retain those data until you receive a formal request. So that's been going on for years. That is in the Budapest Convention of 2001. That has been transposed in our national legislations, and we still just today come across situations where you receive a letter request that has been issued 6 months ago for facts that took place 2 years ago, and there is no way to preserve those data because in Spain we still have in place the law that forces or obliges the telecommunication service providers to retain the data for 12 months, but still we can do nothing. So it looks like there's still a lack of knowledge about everything that is related to electronic evidence. Not to say about the European public prosecutors. You don't have to address those people here. You have to address our colleagues here in this country. So there's still a lot to be. And just the last thing about Article 4.5, the concept of gravity and other conflicting legitimate interests. This is of course one of the bases, or maybe the basis of the concept of proportionality when you use electronic evidence. But still you have to bear in mind that for certain situations where the crime is not really very severe crime, like internet harassment, like those internet pages that tell the girls how to lose weight in 20 days, then they have to go to hospital and die, because I know cases like these. Those in principle are not minor crimes, but they are not really very severe crimes. So that's a very important situation, gravity. But these other conflicting legitimate interests are also of paramount importance. And I guess that these elements should be further developed in this document, because when we read the explanation, there is not additional information. I think this at least a number of situations should be listed there, like a way of example.
Thanks.
Thank you so much, Pedro. I was wondering, Tanya, do you have anything to add? I'm sorry, I cut you off a little while ago, so you might have anything to say to what Pedro and Lorena here has said, and also, of course, what Sylvia said.
Thank you. No, it was your job to cut me off, so no worries for that. What I find interesting in this proposal that it contains very detailed provisions. It's not just general principles. There's also very, very detailed provisions in there. And I have a question more to Lorena, maybe. So first of all, did you work also with defense lawyers to come up with the proposal? And then on the provisions on electronic evidence, in particular, on the forensic standards, for example, how did you come to this very technical provisions. That would be of interest to me.
Thank you. Lorena, will you?
Yes, Tanya, this sounds very, very like music in our ears if you say there is still something interesting in this proposal, so thank you. It means we have done something correctly. Thank you very much, Tanya. To the sources, I would say that we carried out a project led by Bologna University and financed by Olaf on electronic evidence. And within this project, it was very interesting because it was a mixed project, so not only lawyers, but IT people. And we are really delving into the ISO standards. So, and all forensic standards, we looked at the Europol and Interpol forensic labs for access to electronic evidence and the storage of evidence. And then these ISO standards that were based mainly on the UNE standards, which were produced by the Uniform Agency of Crediting and Providing Standards in Spain, and they have been taken over by ISO. So we were inspired by those forensic standards, and we found since there is apparently, as we heard from the IT people, that they are commonly used and there's no objection in among that community that this is the procedure to be followed, we consider this could be elevated to a legislative binding instrument, since there is no objection, and at least in principle there shouldn't be any conflicting national constitutional traditions opposing to these. So this was the tiny intention to try to harmonize a little bit at this stage. I hope we succeed, because it will at least make it enforceable, since and some guidance also for the judges to admit it and be safe that at least it has not been openly hacked or openly manipulated. And the second point on severity of the crime. When I was addressing this issue, I was inspired by the Spanish law, which I think at this technological investigations is quite advanced, and it has been followed by many other countries. So at some points, not only football, we are succeeding in being some example, a good example at least, not in other areas. And it turned out that in assessing the proportionality, it's not only the punishment, not only the severity, it's not only the impact in society, but it might be also considered in minor crimes, as Pedro described, the need to really encroach cyber privacy in order to investigate that crime. And in those cases, even if the crime was not punished with higher than 3 years imprisonment, there might be a judicial authority authorizing to enter into crutch the computer. So we go on the discussion.
I know you could, and and I just asked Sylvia if you would take a closing remark on your side also on what you have heard since your last intervention.
I think I will.
Any carrots?
The carrot, yes,
Yes.
the carrot. I didn't want to leave it aside, because that is important. I think the effort that has been done in order to identify some potential acceptable compromise is enormous. I know that because we've been working on this, for 30 years, so we know how hard it is. And in particular, I think the second part on e-evidence is particularly revolutionary in the sense of offering concrete safeguards. And in particular, all the principles of integrity, of reliability, of pertinence, of adequacy, of authenticity. These are very, very crucial things for the development of next years, in particular, not only for cybercrime, but in general, because e-evidence is all over the place. It's not only for cybercrime. And in particular, I think what is extremely important is to offer, in order to grant some fairness, a support, some expertise in order to analyze the quality of the data. As for the general part of the principles, the thing that I really appreciate is this approach of combining, one hand, the efficiency of a prosecution, but also its fairness, and to involve judicial authorities in concretely controlling the legality of the product. This idea of trying to avoid evidence laundering, it's also a way, an indirect way, to control forum shopping. That doesn't mean that prosecutors have always in mind to do some forum shopping. That's absolutely not my point. And in fact, if we talk about proportionality, and if you have a look to the guidelines adopted by the European Public Prosecutor, they go a step beyond what you just said, Pedro, in relation to the European Investigation Order, in the sense that they are the first ones to suggest that documentation they send to the assisting EDP is much more, it's much richer than the one that you receive for a European Investigation Order. Then, of course, as Lorena said, not everyone will be happy. We will have a lot of voices saying, yeah, this is a step back compared to European Investigation Order, etc. But as you said, here the problem of proportionality in terms of seriousness of the criminal offense is out of the table because of the because of the specific limited competence of the EPPO. Nevertheless, we already had this problem with the European arrest warrant, and I want to refer to this very specific case because maybe next winter we will go back to that. I remember discussions because Italian prosecutors were receiving European arrest warrants concerning theft of wood in winter time to burn in the fireplace. Maybe this winter we will have a lot of these cases. We need to continue the debate on proportionality because it's really, really crucial in this field.
Absolutely. Thank you so much. It shows really how important this topic is, and there's a lot of work still to be done. I would like to thank our 4 panelists. It's been a great pleasure. I will tell you, Silvina, I did look up the EPPO yesterday, and I did also look up Article 31. So I know a little bit now about cross-border investigations. Thank you so much for coming, and I think we should give you a big hand. It's been fantastic.